I want to get your sense, and I want our viewers to understand, this is not uncommon. This happens in a lot of cases.
Correct. All cases. In fact, when you're convicted by a jury, you have an absolute right to an appeal, and it almost is always taken advantage of. I have never seen a murder case or any case that's going to result in significant prison time where a defendant did not take every single opportunity to appeal his conviction, no matter how frivolous they may seem to the public or other interested parties. So nothing unusual about this. There are some surprising aspects to this particular motion that you and Julia already spoke to some degree, but nothing unusual about taking advantage of this process.
I'd love to get your sense of what you consider to be an unusual aspect of this particular motion.
Well, I think that the idea that they're really going after the judge, it appears, I think we all talked about during the course of this trial, why is Mr. Nelson not objecting to the leading nature of these questions? It was really mind-boggling to me as I observed the trial. And I believe it was the sixth prong of the motion. It seems to suggest that the court ordered or allowed or made some permissions for this to happen, which would explain why Mr. Nelson wasn't objecting. So that piece that's very unusual. And, without more context, it's hard to get to what Mr. Nelson is speaking to specifically. But if, in fact, the judge did something to allow leading questions, whether that was to speed up testimony or whatever the rationale was, that would be unusual. And without an appropriate basis, that might have some legs. And, of course, as it's been widely publicized, the issue of jury misconduct. Now, if he's speaking to juror number 52, I don't agree with that analysis. But, I think at the end of the day, this was something that the prosecution did not see coming, that they'll have to respond to at some point in time in the future.
Yeah, and I'd have to agree with you about the objections regarding the leading questions. At the time when we were discussing it with some other guests as well, Jamie, I thought there may have been even an agreement between the parties that they wouldn't object to each other. It was just so pervasive and so obvious. So maybe what he's referring to when he says some of the sidebars didn't get on the record, maybe in one of those sidebars there was some sort of agreement or some sort of directive by the judge. So that'll be interesting to watch that argument as well. I want to talk a little bit about, before we get to the juror, this abuse of discretion issue. And I also want our viewers to understand that that is an extremely high bar. If and when this goes to an appeals court, they give great deference to the decisions made by judges. I played some of the sound when the judge gave his reasoning behind not allowing for the change of venue, and I don't think there is a particularly strong area for the defense.
No, I don't think so. And you're absolutely right. When this gets to the Court of Appeals, which it will, they are not allowed to reanalyze the evidence. They can't retry the case. Mr. Nelson will not be arguing that the jury got something wrong. What he'll be arguing is what he's already arguing, that the court made mistakes and there was misconduct on the part of the prosecutor and or jurors. And in order to show that a judge or a court did something wrong, it's an extraordinarily high bar. And I certainly don't think that anything Judge Cahill did that I'm aware of rises to that level. In particular, the change of venue motion. And I think Judge Cahill summarized it appropriately. I mean, so the argument, I suppose, would be, or the counter argument is, if you do something so egregious that the entire state of Minnesota is going to know about it, then we can't try you because there's nowhere to try you. And that's not a reasonable solution. So I believe that on their merits, as they're presented right now, these arguments will certainly not go anywhere with Judge Cahill. And I'll be shocked if the Court of Appeals gives them any significant deference as well.
All right, now.